our discussion by anything that exists. So if you do not want, we won't discuss anything that exists. We can go straight into what it should be and what issues that you have looked at, anything. I mean, broad canvas, blank canvas, the way you want to take it. So, Jonathan, thank you very much for being part of the symposium, and of course, all the wonderful conversations we've had in evolution of a mediator and otherwise. So thank you very much.
My pleasure. Always a great pleasure to work with you, Vikram.
No, it's been really nice have those. What I want to do is just give me 1 second to put up what we are doing. What we are doing is this symposium number 8. So this is mediation legislation, and I just put out questions. The idea is to question everything. So how, what, when, where, which, who, why. Let's question everything about it, because look, finally we want to. What our purpose is that mediation should develop and develop in the right way. So for that, whatever needs to happen. So this is now what has happened, Jonathan, is that of course I always start. Okay, let's have a few people together and let's have the discussion. Now they've gone to about 50 people. So it's going to be, I mean, I think it'll be interesting. I think that 30 countries now which are represented. So that'll be interesting. So this is what we're doing. And of course, people can get information about what I do on mediatorvikram.com. I won't take your time on that. So Jonathan, it's all about, if a little bit about yourself, if you want to talk about, although people know you, but still just a little bit.
Now, Vikram, you must guide me what you would like to know about me, because the fact that I might be a stamp collector, which I'm not, is unlikely to be of huge interest to your audience. Okay, a quick snapshot. Most of my working life, I practiced as a shipping lawyer, enunciating that more carefully, shipping lawyer, not liar. And yes, mostly shipping, international trade, international commercial law areas. And then in 2012, I retired from as a partner in the law firm and went back to school, was admitted as a barrister at Gray's Inn, and sat with the barristers' chambers for the next few years, but practicing mostly as mediator and arbitrator, also carrying out, helping certain former clients with major projects that they were engaged in. For example, one of those was a former Minister of Justice of one of the smaller EU countries, and got involved in a private capacity in a number of interesting projects, which he wanted me to work alongside him on. But principally, I was working as mediator and arbitrator. And then just quite recently, 2018, I decided to set up my own little mediation panel. Well, I called it Lux Mediation, and frankly, originally had in mind that it would be Mr. Lux himself and not much else. But then I was approached by various different people, firstly an eminent practitioner from Singapore, a former master mariner, had been a regional director for one of the major P&I clubs. That's the P&I clubs are the liability insurers looking after ship owner charterer interests. Their insurance they're insuring their liabilities. And he was also he is also a practicing mediator and arbitrator, and it was in that capacity that he wanted to join. And then there have been various others, an eminent QC, or now KC, King's Counsel, who was based in Brussels, eminent EU law expert, and then also some leading practitioners from France, Italy, and Spain. So, and it's an eclectic little group. Frankly, they're all very senior highly regarded individuals, but the main qualification to join is it has to be someone I would enjoy spending an evening in the pub with, clubbable, good company therein. So that's the panel, and that's in a nutshell what I now do.
Yeah. Important thing is that if you want to know more about Jonathan's life, there is a series called Evolution of a Mediator, where, of course, we've discussed Jonathan's life and growing up and everything. So that's available. I mean, easy thing is for people to go to YouTube and search Mediator Vikram and Jonathan Lux, and they'll find all those episodes. So that's, of course, those have been interesting conversations. So
you'll have to remind me, Vikram, whether I made any embarrassing disclosures during that series, because if so, I've forgotten.
I'm not going to tell you, otherwise you won't make them again. So
yeah, you're right.
so Jonathan, mediation legislation in general, UK, everything, please.
Well, like many things, if you can operate unregulated, how nice is that? But of course, there need to be safeguards. So mediation is a profession. There must be professional standards. Those coming to mediators must be assured that there are standards, that there's accountability, and that if there's breaches of the standards, there are penalties to pay. All those are givens. And I believe that at the moment, it's not mandatory to have any professional qualification or kite mark, or indeed mandatory to have any insurance in place to put up a name plaque saying, I practice as mediator. Although certainly those of us who care about these things are accredited by, in my country, the CMC, the Civil Mediation Council, which does require that a certain level of CPD, there's a code of conduct, there's insurance that one should take out, and so on. And those are all important things because they're safeguards to the public. And the worst thing is that there be rogue mediators who get away with roguery and no sanctions for that. It would give the profession a bad name, and we can't afford when we're trying to. Those of us who feel strongly that there must be more mediation and that it is the best way to resolve disputes, obviously have a keen interest in seeing that the highest standards are followed. So there's nothing mandatory, I believe, at the moment, but all the mediators I know practicing in the commercial space would belong to the CMC, and some of us also to the International Mediation Institute, the IMI, and that carries with it certain obligations in terms of standards and insurance and so on.
Well, I think maybe the starting point, because I think maybe to a certain extent we differ on that, and which I think differ with a lot of people, is that we start with it being a profession. So in the World Mediators Conference, I had a discussion on, is it a profession or is it a way of life? So I think that part of it needs to be discussed, because I think legislation is in a way going around that part. So you think it's a profession, that's the way you look at it. And you think in terms of it being a way of life, and because in terms of understanding it, there's a difference there. So mediation has not developed the way it should have, because on one end, we are trying to put it into this profession bracket, while actually is it a grassroots activity where people just have to find a person they trust and get the person in and go beyond that. I don't know. I mean, I just thoughts, Jonathan. What are your thoughts on that?
Well, look, if you're people may not be too interested when they're in the midst of a dispute with what my way of life may be, but they are interested to know that there are strict rules, accountability, and sanctions if I'm allowing one party to bribe me to secure a certain outcome or try and secure a certain outcome. So seriously, we have to regard ourselves as a profession with the duties of professionals to uphold the highest standards. And that's why we can ask the public to trust us with their disputes. So it's not just a way of life. It's a way of life of a professional upholding the highest standards.
Well, that's Jonathan, when I look at the figures, because CEDAR took out a report, there was a mediation audit, 10th mediation audit report that they took out.
Yeah.
And they say that there are 17,000 cases which have been mediated in the UK. And that sounds to me that somewhere there is an issue there, because yes, everything is being put into place. There are certifications and everything that's gone into it. And as I don't know exact figure, but Andrew Miller 2 years back said there are 18,000 certified mediators. But I mean, I don't know what figures. I haven't gone into it, but I'm sure there are some figures available. I don't have it in front of me. But let's just look at it from that perspective. So on one end, we do want to say that, yes, this whole structure is to be created. But where is the work for those people? Why isn't that happening? Where is the mismatch?
Well, you're right. It's a slow burn. It's not been sort of dynamic in terms of growth. It's more evolutionary. But then, so one sees with new courts. For example, I was based in Hamburg for a period, and close by the International Tribunal for the Law of the Sea. And it took quite some years before that started to get some traction. We're seeing traction now in mediation, but still, less than 20,000 when there are something like, if I remember rightly, 200,000 new civil cases started every year. Obviously, it's a tiny number. And potentially all of those 200,000, or the great majority, should be ripe for mediation at some point, hopefully early on, before too much in the way of costs has been expended. So there are several factors, though, that are now pointing in the right direction for mediation. One is that, of course, costs inexorably continue to rise if you go to court, or also to arbitration. Secondly, there was a question mark over enforceability. So, the point is, I guess, that you've got a dispute because one party would say the other party didn't respect the contract. And then you go to mediation and you end up with a second contract, the mediation agreement. And who's to say that will be better respected than the first contract is one view. So the idea that there should be enforceability of the mediation settlement agreement is a good thing. And some say that it was the New York Convention on the enforcement, reciprocal recognition and enforcement of arbitration awards, which propelled arbitration into the number one position for resolution of international commercial disputes. And therefore, some would say that the Singapore Mediation Convention may help in a similar way to make mediation more acceptable to commercial parties. The knowledge that mediation settlement agreements can be enforced in the jurisdiction where the paying party has his assets, if that state of courts has signed up to the convention. And we have the very recent news in my jurisdiction that the intention is for the UK to sign up to the Singapore Convention. Still don't know what Brussels is doing in that regard, whether the EU will sign up en bloc or whether indeed some individual EU member states will say that they can sign up on their own. I don't know where we stand on that, but the UK is in the process of adopting the Singapore Convention, which I think is a very good thing for mediation in this jurisdiction. It will help without doubt. Another quite recent development is steps to make mediation mandatory, admittedly at the moment for small claims only. But there are those who say that this is just the starting point and that it will spread, and that we can anticipate that perhaps next step, all county court claims, which would mean that quite a proportion of the 200,000, if it's still 200,000, I'm not vouching for the figures, but quite a substantial proportion of those may, in the not too distant future, be subject to mandatory mediation at some point. Mandatory mediation, of course, is a mixed blessing. There are some who say that it'll be difficult to guarantee the quality of the number of mediators who will then be needed to mediate that vast number of disputes. And if there are very poorly conducted mediations, it will bring mediation as such into disrepute. So it's not an unmixed blessing, but it potentially will mean that mediation is much more widespread. And if we can look after standards and the quality of the mediations offered, then it's, of course, a good thing for mediation.
But Jonathan, this part of course, you are going to talk about this legislation for mandatory mediation. We will talk, of course, look at that in Singapore Convention. But one thing, let me just ask you, when we have 18,000 certified mediators out there, I don't know how many are registered with the CMC, but if they're all out there, why hasn't the user taken to it? I mean, I'm sure they're going out and telling people that mediate and I am certified and whatever. I don't know what they're going out and say. But if that is happening, what is really happening on the ground? I mean, do you have any idea what's really happening? Because a person gets certified, what does the person do? Because it's a practice that they want to, like you said, profession. So when you take up a profession, you normally reach out. So what is the response they get? Where is the issue? I mean, I really want to understand, but 17,000 on one end and 18,000 mediators, there's a major mismatch there. What is happening on the ground there?
Frankly spoken, I've no idea. I do get regularly calls from newly qualified mediators who ask effectively, how do I build up my practice? And there's no easy answer to that. Most, at least I think till now, mediation tends to be a second profession. So the majority have, started life as a solicitor, barrister, perhaps surveyor, perhaps architect, whatever it may be, and then are coming to mediation as a second profession. So I guess in those cases, if that's the position, then your primary client base is going to be the partners in your law firm, the other law firms you dealt with, the barristers you dealt with, and so on. So your professional contacts database is going to be the source of probably most of your instructions. So if you come to mediation without that possible resource, then indeed it must be tough to build up, to get traction.
Yeah, because I'm just thinking, because I get messages from the disillusioned ones. Because I tried, I went in for all this training, certification, and all, nothing's coming. I'm leaving this. So and of course, a lot of them are not lawyers also. So that part of it, they have the passion, they want to do it, but practice doesn't happen. Was why I'm connecting the two is because, like you said, that mandatory mediation is a step that is being taken. And already, I think the way it is structured in the court system, there certain judgments have come out from the courts in the UK in relation to good faith mediation, when you went into it in a good faith or not, and reasonable proposals and all those kinds of things. Some things have happened there. But I'm just thinking that if is it that the people who are out there and who are certified and accredited and everything, are they not being able to deliver? Because finally you'll have to use some mediators. Even if you push people into mediation, you'll have to use some people. Is the entire process flawed, or the people coming out, is there an issue there? Because we might tomorrow say legislate on these aspects also, but is there a fundamental issue with the process of certification? So is there something there? I mean, why is, because I really want to understand the user and mediator connection not happening. What is the thing there?
So we're moving from way of life where anything goes, I feel like being a mediator, to certification. No, that's standards I'm not aware of. In the UK, lots of discontent with poorly conducted mediation. I'm not a poorly conducted mediations. I'm not aware of that as being a factor. So I think, frankly, the cynical might say that most lawyers charge on a time basis. And, frankly, it's very difficult for lawyers in the sense that in many firms, they're required to produce a certain number of billable hours each month and to generate a certain level of billings. And it's obvious, isn't it, that if you're in litigation, which may run for years, as opposed to mediation, where the matter may be successfully resolved after a period of perhaps a few months, that it's a bit of a conflict, isn't it, for the lawyer? And sometimes in my own law firm, I had people question whether I was a little bit like a turkey voting for an early Christmas. And I would suggest that that's really misguided. I said, look, to those who made that suggestion to me, think about it for a moment. Most of your clients come to you with their litigation cases through gritted teeth. They know it's going to cost them an arm and a leg. It's going to last much longer than they'd thought in their worst nightmare. It's going to involve much more time, even though they've employed you, their lawyer, to conduct it. You will have an insatiable appetite for documents, for witness evidence, and so on and so forth. So they're bringing their litigation cases to you through gritted teeth. If you can demonstrate to those clients that you can get the matter successfully resolved in a fraction of the time, at a fraction of the cost that they had anticipated would be required, then they will fling open the doors of their filing cabinets and say, please, take more of these cases. That was a wonderful experience. So, it depends how you view it. But I think if one can get over to those concerns, that far from it being yet another burden, that they can make a virtue out of what I regard anyway as a necessity, because the word is spreading. More and more people are aware of mediation as an option. And, therefore it's coming, it's an idea whose time has come. And the lawyers had better embrace it.
Because I'm looking at from what you just said. Look, there's a certain mindset that you have. You've been part of the adversarial system, but you still have that mindset that you want to assist people in settling. And that's the mindset that a lot of people might have. And those are the people I feel who have to be brought into. I'll use the word profession, Jonathan, but I will still, whether I agree with that part, whether profession, because I'll tell you why. Because when the moment you start creating it into a profession, then you've gone into a direction of saying, we can train you and we will certify you. Because that's what a profession wants. I mean, that's what a profession requires. So training and certifications. And I'm just thinking in terms of, even we will talk about legislating these two aspects. So if we are saying that there is a certain training that can be done, how do I create Jonathan's mindset in that training? I have an issue with that part, because it's a mindset thing. And you can talk about theory of everything about conflicts and everything theory, but creating the mindset is what I feel will really change things when people like you are out there who have that mindset. So a way of life part of it for me comes from that there are people with that mindset. They're all out there. They're part of communities, and they have been, I mean, you can't do away with those people. They have that mindset. So we have, for me, channelizing that. And okay, I talk about the legislation because I have certain ideas, but I don't want to push those ideas. I really don't want to push them. But I feel that a very basic legislation, the way we have in India today, we were talking just before yours, we had a session with Mr. Panchu. He's like, I could say the mediator in India, and I was talking to him about the same thing, about the legislation that we have. So how simple should it be? And then when it comes to legislating on the mediators itself and certifications, are we really looking at mediation in the right way? Because for anyone to say X is someone I am certifying has that kind of approach to it, maybe has a different approach. For me to tell anyone that yes, you are in the right way, and say to someone else that you are not, because I'm gauging that person from my way of going about life and conducting myself, I think the process by itself is misunderstood, because it's just an individual's way of dealing with people. It's a people to person thing, and how they deal with it. Yeah, Jonathan, you were saying something.
Vikram, I just wanted to mention this. As I mentioned before we started this afternoon, I've unfortunately got a time limit that I've got to be away at, and it's almost time up, and you just launched a really big question.
We'll do it. We'll do a part two,
which you have a great knack of doing. So regulate or don't regulate, how do you guarantee that you get people of the right mindset? These are huge questions, and so important to, mediation taking off in the way you would want it, I would want it. Look, we've got, a lot of really good people in the mediation space, not just in my jurisdiction, around the world. And we must continue to engage and talk and discuss these critical issues, so that mediation continues to have the best launchpad it can for taking a bigger hold in resolving disputes. And my apologies, Vikram, but I've really got to get on to something else now. So I hope that little excursion with you this afternoon is of some value.
Okay, so this is like just the, I mean, okay, this is a starting point. We'll have, what we can do is the symposium goes on till the 19th. Anytime in between you have time, we'll do a part 2 when we'll take up the discussion, because it is important. I mean, and you are important in terms of what your thoughts on this are. So we'll do it again. I mean, do another part 2. What's the problem? This is my
Okay.
symposium. I can do these
You're very
things.
persuasive. You're very persuasive.
So
So very nice to spend a bit of time with you this afternoon. And yeah, until soon.
yeah, soon we'll fix up whenever you have time. We'll fix up a time. Not a problem at all.
Okay, brilliant.
Thank you. Thank you very much, Jonathan.